Question 1. Comparative studies suggest that following the United Kingdom's departure from the European Union, companies previously relying on EU product safety directives for market access in the UK now face a complex regulatory environment. For a company based in Alabama that exports products to the UK, what is the most prudent course of action to ensure continued compliance with product safety regulations in the UK? Option A. Proactively research and identify specific UK product safety regulations and conformity assessment procedures that have replaced or amended the previous EU directives, and adjust product compliance strategies accordingly. Option B. Assume that the regulatory landscape for product safety in the UK has not significantly changed and continue with existing compliance practices. Option C. Seek general advice from international trade consultants to understand the broad implications of Brexit on trade, without focusing on specific product safety regulations. Option D. Continue to rely on existing EU product safety certifications, assuming they remain valid for the UK market until explicitly invalidated. Correct answer is A. Proactively research and identify specific UK product safety regulations and conformity assessment procedures that have replaced or amended the previous EU directives, and adjust product compliance strategies accordingly. Explanation. The scenario presents a professional challenge for a company operating in Alabama, which must navigate the implications of Brexit on its product safety regulations. The core difficulty lies in determining whether existing EU product safety standards, which were previously applicable in Alabama through EU directives, remain relevant or, if new, potentially divergent, UK-specific regulations now supersede them. This requires a nuanced understanding of how international trade agreements and regulatory frameworks interact with domestic law, demanding careful judgment to ensure compliance and avoid market access issues or consumer harm. The best professional approach involves proactively identifying and assessing the specific UK product safety regulations that have replaced or amended the previously applicable EU directives. This requires diligent research into the UK's post-Brexit regulatory landscape, including any transitional arrangements or new conformity assessment procedures. By understanding these specific UK requirements, the company can then determine the necessary adjustments to its product design, testing, and documentation to ensure compliance with the new regulatory regime. This approach is correct because it directly addresses the legal and practical consequences of Brexit on product safety, ensuring that the company's products meet the standards mandated by the relevant jurisdiction, in this case, the UK's post-Brexit framework. Ethically, it prioritizes consumer safety by adhering to the most current and applicable standards. An incorrect approach would be to assume that existing EU product safety certifications remain valid indefinitely without verification. This failure to acknowledge the regulatory shift post-Brexit could lead to non-compliant products entering the UK market, potentially resulting in recalls, fines, and damage to the company's reputation. This approach is ethically questionable as it risks consumer safety by relying on outdated standards. Another incorrect approach is to solely rely on advice from a general trade consultant without specific expertise in UK product safety law. While such consultants can offer broad guidance, they may not possess the detailed knowledge of specific UK regulations, conformity assessment bodies, or labeling requirements that have evolved since Brexit. This could lead to incomplete or inaccurate compliance strategies, exposing the company to regulatory risks. A further incorrect approach is to ignore the changes altogether and continue operating under the assumption that no significant regulatory divergence has occurred. This passive stance is highly problematic, as it demonstrates a disregard for the legal and regulatory realities of post-Brexit trade. It not only risks non-compliance, but also signals a lack of due diligence and a failure to adapt to a changing international environment, which can have severe business and ethical repercussions. Professionals should employ a decision-making framework that begins with identifying the specific regulatory jurisdiction applicable to their products in the target market. This involves understanding the legal basis for regulatory requirements, whether derived from international agreements, national legislation, or specific directives. Following this, a thorough assessment of the current regulatory landscape in that jurisdiction is crucial, paying close attention to any changes or updates, particularly those stemming from significant geopolitical events like Brexit. Once the applicable regulations are identified, a gap analysis should be performed to compare existing compliance measures against the new requirements. Finally, a plan for implementing necessary changes, including product modifications, testing, and documentation updates, should be developed and executed, with ongoing monitoring to ensure continued compliance. Question 2. The investigation demonstrates that a financial advisor in Alabama is assisting clients whose portfolios include investments in UK-based companies. Given the UK's departure from the European Union, what is the most prudent approach for the advisor to take regarding the overview of the UK's trade agreements post-Brexit and their potential impact on client investments? Option A. Proactively research and analyze the specific terms and implications of the UK's new trade agreements, integrating this understanding into personalized investment recommendations, and clearly communicating the rationale and potential impacts to clients. Option B. Focus solely on domestic U.S. market trends, disregarding any potential influence of international trade agreements on the performance of UK-based investments held by clients. Option C. Rely on general media coverage of Brexit to form an opinion on the UK's trade landscape and make broad investment adjustments based on this overview. Option D. Assume that the UK's trade agreements post-Brexit have minimal impact on existing investment strategies and continue with current advice without further investigation. Correct answer is A. Proactively research and analyze the specific terms and implications of the UK's new trade agreements, integrating this understanding into personalized investment recommendations, and clearly communicating the rationale and potential impacts to clients. Explanation. The investigation demonstrates a scenario where a financial advisor in Alabama, dealing with clients who have investments impacted by the UK's post-Brexit trade landscape, must navigate complex international trade agreements and their implications for investment strategies. This is professionally challenging because the advisor needs to understand how the UK's withdrawal from the European Union has reshaped its trade relationships, potentially affecting market access, regulatory environments, and investment opportunities for clients. Misinterpreting these agreements could lead to suboptimal investment advice, regulatory breaches, and client dissatisfaction. Careful judgment is required to translate abstract trade policy into actionable financial advice. The best professional approach involves proactively researching and understanding the specific terms and implications of the UK's new trade agreements, such as the Trade and Cooperation Agreement with the EU and any bilateral agreements with other nations. This includes analyzing how these agreements affect sectors relevant to the client's portfolios, identifying potential risks and opportunities arising from new tariffs, regulatory divergence, or market access changes. The advisor should then integrate this analysis into personalized investment recommendations, clearly communicating the rationale and potential impacts to clients. This approach is correct because it aligns with the fiduciary duty to act in the client's best interest, requiring a thorough understanding of all material factors influencing investment performance, including significant geopolitical and economic shifts like Brexit and its trade consequences. It also adheres to principles of professional competence and due diligence mandated by financial regulatory bodies. An incorrect approach would be to ignore the impact of Brexit on UK trade agreements, assuming that existing investment strategies remain unaffected. This failure to adapt advice to evolving international trade dynamics demonstrates a lack of due diligence and professional competence, potentially exposing clients to unforeseen risks. Another incorrect approach is to rely solely on generalized news reports about Brexit without delving into the specifics of the UK's trade agreements. This superficial understanding is insufficient for providing tailored and informed advice, as it lacks the granular detail needed to assess specific investment impacts. Furthermore, an approach that involves making speculative investment decisions based on assumptions about future trade deals, rather than on the analysis of existing agreements, is professionally unsound and ethically questionable, as it prioritizes potential gains over a well-reasoned, evidence-based strategy. Professionals should employ a decision-making framework that prioritizes continuous learning and adaptation. This involves 1. Identifying significant external factors like Brexit that could impact client investments. 2. Conducting thorough research into the specific regulatory and economic consequences of these factors, focusing on the relevant jurisdiction, UK trade agreements in this case. 3. Analyzing the implications of this research for individual client portfolios, considering their risk tolerance and financial goals. 4. Developing and communicating clear, well-substantiated recommendations. 5. regularly reviewing and updating advice as the situation evolves. Question 3. Analysis of the legal framework of the European Union. What is the most appropriate initial step for a financial advisory firm based in Alabama to determine if any EU regulations have direct applicability to its operations, considering Brexit has occurred and Alabama is not an EU member state? Option A. Focus solely on U.S. federal and Alabama state regulations, as these are the only legal frameworks that govern the firm's operations, and disregard any potential influence of EU law. Option B. Assume that all EU regulations, including those related to financial services, are potentially applicable to any firm operating in a developed economy, and begin a broad compliance review of all EU directives and regulations. Option C. Conduct a detailed review of the firm's current and prospective business activities to identify any direct or indirect engagement with the European Union's internal market, including cross-border transactions, client relationships with EU residents, or the provision of services into EU member states. Option D. Conclude that as Alabama is not an EU member state and Brexit has occurred, no EU regulations can possibly apply to the firm's operations, and therefore no further investigation is necessary. The correct answer is C. Conduct a detailed review of the firm's current and prospective business activities to identify any direct or indirect engagement with the European Union's internal market, including cross-border transactions, client relationships with EU residents, or the provision of services into EU member states. Explanation. Scenario analysis. This scenario presents a professional challenge due to the complex interplay between national sovereignty and the legal framework of the European Union, particularly in the context of a jurisdiction like Alabama, which is not an EU member state but might engage in trade or have citizens affected by EU regulations. The challenge lies in accurately identifying which EU legal instruments, if any, would have direct applicability or indirect influence on a business operating solely within Alabama, and understanding the limitations of such influence. Careful judgment is required to avoid misinterpreting the scope and effect of EU law on non-member entities. Correct approach analysis. The best professional practice involves a rigorous assessment of the specific nature of the business operations in Alabama and any direct or indirect connections to the European Union. This approach correctly prioritizes understanding whether the business is exporting goods or services to the EU, has subsidiaries within the EU, or is otherwise subject to EU jurisdiction through specific international agreements or targeted legislation. The justification for this approach lies in the fundamental principle of territoriality in law. EU law generally applies within the territory of EU member states. For a business in Alabama, EU law would only become relevant if there is a demonstrable nexus, such as engaging in trade with the EU market, which would then trigger specific EU regulations governing that trade. This requires a factual investigation into the business's activities and their cross-border implications, aligning with principles of legal certainty and due diligence. Incorrect approach is analysis. One incorrect approach is to assume that any EU regulation, regardless of the business's activities, has potential implications for an Alabama-based company. This fails to recognize that EU law's extraterritorial reach is limited and typically requires a direct link to the EU's internal market or its member states. This approach risks overcompliance or misallocation of resources based on a misunderstanding of jurisdictional boundaries. Another incorrect approach is to dismiss all EU regulations as irrelevant without a thorough investigation. While EU law primarily governs member states, certain EU regulations can have indirect effects or set standards that influence global markets, including those in non-EU countries. For instance, product safety standards or data protection regulations, like GDPR, can impact businesses worldwide if they interact with EU citizens or markets. Ignoring this possibility without due diligence is professionally unsound. A further incorrect approach is to rely solely on general knowledge of EU law without considering the specific context of Alabama's legal system and its relationship, or lack thereof, with the EU. Alabama operates under U.S. federal and state law. While international trade can bring foreign legal frameworks into play, the starting point must be the specific nature of the business's engagement with the EU, not a broad assumption of applicability. Professional reasoning. Professionals should adopt a structured, fact-based approach. First, clearly define the scope of the business's operations and identify any existing or potential international engagements. Second, research specific EU legal instruments that might be relevant to those engagements, focusing on regulations that explicitly address cross-border activities, trade, or data flows involving non-EU entities. Third, consult with legal experts specializing in international trade law and the relevant EU regulatory areas to confirm the applicability and implications of any identified EU laws. This systematic process ensures that legal obligations are accurately identified and addressed, preventing both undercompliance and unnecessary overcompliance. Question 4. Consider a scenario where a company based in England is planning to ship a consignment of manufactured goods to its warehouse in Belfast, Northern Ireland. Given the specific requirements of the Northern Ireland Protocol, what is the most appropriate course of action for the company to ensure compliance with customs and regulatory obligations for this shipment? Option A. Proceed with the shipment by completing standard UK customs declarations, assuming no additional requirements beyond those for domestic UK trade, as Northern Ireland remains part of the United Kingdom. Option B. Rely solely on general UK import/export guidelines and delay implementing any specific measures related to the Northern Ireland Protocol until further clarification is received from regulatory bodies. Option C. Treat the shipment as a standard domestic transfer within the UK, only requiring basic internal transit documentation and no external customs declarations or regulatory checks. Option D. Ensure all necessary customs declarations are completed and goods are prepared for potential EU conformity checks and any applicable tariffs, as if entering the EU customs territory, recognizing the unique status of goods moving from Great Britain to Northern Ireland under the Protocol. The correct answer is D. Ensure all necessary customs declarations are completed and goods are prepared for potential EU conformity checks and any applicable tariffs, as if entering the EU customs territory, recognizing the unique status of goods moving from Great Britain to Northern Ireland under the Protocol. Explanation. Scenario analysis. This scenario presents a professional challenge due to the complex interplay of international trade law, domestic legislation, and the unique political and economic realities of the Northern Ireland Protocol. Professionals must navigate potential conflicts between UK law, EU law as applied to Northern Ireland, and the specific commitments made under the Protocol. Misinterpreting or misapplying these frameworks can lead to significant legal, financial, and reputational damage for businesses and individuals operating in or trading with Northern Ireland. The need for precise understanding of customs procedures, regulatory alignment, and dispute resolution mechanisms is paramount. Correct approach analysis. The best professional approach involves a thorough and precise understanding of the Northern Ireland Protocol's specific provisions regarding goods moving from Great Britain to Northern Ireland. This includes recognizing that such goods are subject to EU customs procedures and regulatory checks, even though they remain within the United Kingdom. Therefore, correctly identifying the applicable customs declarations, potential tariffs, and conformity assessments as dictated by the Protocol is essential. This approach is correct because it directly adheres to the legal obligations and operational requirements established by the Protocol, ensuring compliance with both UK and EU law as it applies to Northern Ireland. It prioritizes accurate classification of goods and adherence to the stipulated checks and documentation, thereby mitigating risks of noncompliance, delays, and penalties. Incorrect approaches analysis. One incorrect approach would be to assume that goods moving from Great Britain to Northern Ireland are subject to the same customs and regulatory regime as goods moving between 2 points within Great Britain. This fails to acknowledge the specific provisions of the Northern Ireland Protocol, which treats goods entering Northern Ireland from Great Britain as if they were entering the EU customs territory for certain purposes. This leads to a failure to implement necessary declarations and checks, risking penalties and disruption. Another incorrect approach would be to solely rely on general UK customs regulations without considering the specific deviations and additional requirements introduced by the Northern Ireland Protocol. While UK regulations provide a framework, the Protocol creates a distinct set of rules for goods entering Northern Ireland. Ignoring these specific rules constitutes a significant oversight and a failure to comply with the operative legal framework. A further incorrect approach would be to adopt a wait-and-see attitude, delaying the implementation of necessary compliance measures until specific enforcement actions are taken. This passive stance is professionally unacceptable, as it exposes the business or individual to immediate risks of noncompliance and potential penalties. Proactive understanding and implementation of the protocol's requirements are crucial for responsible operation. Professional reasoning. Professionals should adopt a proactive and diligent decision-making framework. This involves 1. Identifying the specific jurisdiction and relevant legal instruments, in this case, the Northern Ireland Protocol and associated UK and EU legislation. 2. Analyzing the nature of the goods and the intended movement, Great Britain to Northern Ireland. 3. Consulting authoritative guidance from relevant government bodies and trade organizations. 4. Implementing robust internal processes and training to ensure compliance with all stipulated customs procedures, declarations, and regulatory checks. 5. Regularly reviewing and updating practices in response to any changes or clarifications in the regulatory landscape. Question 5. During the evaluation of a client's investment portfolio that includes UK-domiciled securities, an Alabama-based financial advisor must ensure their advice remains compliant with all applicable regulations. Considering the post-Brexit regulatory environment, which of the following actions best demonstrates adherence to professional and regulatory obligations? Option A. Relying on general knowledge of international financial markets and assuming UK regulations mirror those of the United States in the absence of explicit contrary information. Option B. Waiting for specific client questions or issues related to UK investments to arise before investigating any potential post-Brexit regulatory changes. Option C. Actively researching and applying the latest guidance from both U.S. regulatory bodies, e.g., SEC, FINRA, and relevant UK authorities, e.g., FCA, regarding cross-border financial services and investments. Option D. Continuing to operate under the assumption that pre-Brexit regulatory frameworks for UK investments remain fully applicable without further verification. The correct answer is C. Actively researching and applying the latest guidance from both U.S. regulatory bodies, e.g., SEC, FINRA, and relevant UK authorities, e.g., FCA, regarding cross-border financial services and investments. Explanation. The scenario presents a professional challenge due to the inherent uncertainty and evolving legal landscape following Brexit, particularly concerning cross-border financial services between Alabama and the United Kingdom. A financial advisor in Alabama must navigate the complexities of ensuring compliance with both U.S. federal regulations and any residual or new UK regulations that might impact their clients' investments or advisory services. The need for accurate, up-to-date information and a clear understanding of regulatory divergence is paramount to avoid potential breaches of fiduciary duty and regulatory sanctions. The best approach involves proactively seeking and applying the most current guidance from relevant regulatory bodies in both jurisdictions. This means consulting official publications from the U.S. Securities and Exchange Commission, SEC, and the Financial Industry Regulatory Authority, FINRA, for U.S.-based requirements, and simultaneously researching guidance issued by the UK's Financial Conduct Authority, FCA, or other relevant UK authorities concerning financial services operating post-Brexit. This approach prioritizes accuracy, regulatory adherence, and client protection by ensuring all advice and actions are grounded in the latest legal and regulatory frameworks. It demonstrates a commitment to due diligence and professional responsibility in a complex international regulatory environment. An incorrect approach would be to rely solely on pre-Brexit agreements or general knowledge of international finance without verifying specific post-Brexit regulatory changes. This fails to acknowledge the significant legal and operational shifts that have occurred, potentially leading to advice that is no longer compliant or suitable for clients. Another flawed approach is to assume that UK regulations have remained static or are easily inferred from US regulations. This oversight ignores the distinct regulatory paths each jurisdiction may take and could result in non-compliance with specific UK requirements for services or products that have a UK nexus. Finally, delaying the review of regulatory changes until a client inquiry arises is a reactive and risky strategy. It fails to uphold the proactive duty of care expected of financial professionals and increases the likelihood of inadvertently providing non-compliant advice. Professionals should adopt a decision-making framework that emphasizes continuous learning and proactive compliance. This involves establishing a regular process for monitoring regulatory updates from all relevant jurisdictions, engaging with professional bodies for insights, and consulting legal counsel when significant ambiguities arise. The framework should prioritize client interests by ensuring that all advisory activities are conducted with a thorough understanding of the applicable legal and regulatory landscape, especially in areas affected by major geopolitical events like Brexit. Question 6. Research into the implications of the United Kingdom's withdrawal from the European Union, Brexit, on financial services firms operating within Alabama's regulatory framework reveals a need for careful risk assessment. Which of the following approaches best addresses the potential compliance challenges arising from this geopolitical event? Option A. Adopt a passive stance, waiting for explicit guidance from the Alabama Securities Commission or other state regulators before implementing any changes to current operational or client advisory practices. Option B. Assume that general equivalence between UK and US financial regulations will be maintained post-Brexit, negating the need for specific analysis of Alabama's unique legal requirements. Option C. Operate under the assumption that U.S. federal regulations entirely supersede all state-level financial services laws in Alabama concerning UK-originated business, rendering state-specific considerations irrelevant. Option D. Proactively identify specific areas of Alabama financial services law that may be impacted by Brexit, such as data protection and cross-border trading rules, and consult with legal counsel specializing in both U.S. and UK financial regulations to interpret potential impacts and develop compliance strategies. The correct answer is D. Proactively identify specific areas of Alabama financial services law that may be impacted by Brexit, such as data protection and cross-border trading rules, and consult with legal counsel specializing in both U.S. and UK financial regulations to interpret potential impacts and develop compliance strategies. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent uncertainty and evolving nature of post-Brexit regulatory landscapes for financial services firms operating in Alabama. The complexity arises from the need to navigate potential divergence in regulations between the UK and the US, specifically Alabama, and to ensure ongoing compliance without a clear, established framework for UK-US financial services equivalence post-Brexit. Professionals must exercise careful judgment to identify and mitigate risks that could impact client services, operational continuity, and regulatory standing. Correct approach analysis. The best professional practice involves proactively identifying specific areas of Alabama financial services law that may be impacted by Brexit, such as data protection, cross-border trading rules, and prudential requirements for UK-based entities operating in Alabama. This approach necessitates a thorough review of existing Alabama statutes and regulations, alongside any pronouncements from the Alabama Securities Commission or other relevant state bodies concerning UK financial services. It requires engaging with legal counsel specializing in both U.S. and UK financial regulations to interpret potential impacts and develop compliance strategies. This proactive, jurisdiction-specific risk assessment ensures that the firm remains ahead of potential compliance gaps and can adapt its operations and client advice accordingly, aligning with the Alabama regulatory framework's emphasis on investor protection and market integrity. Incorrect approaches analysis. Relying solely on general assumptions about the equivalence of UK and US financial regulations post-Brexit without specific analysis of Alabama law is a significant failure. This approach ignores the distinct regulatory authority of Alabama and risks non-compliance with state-specific requirements. It also fails to acknowledge that Brexit has created regulatory divergence, not automatic alignment. Assuming that all UK financial services regulations are automatically superseded by US federal regulations, without considering Alabama's specific state-level oversight, is another critical error. Alabama maintains its own regulatory framework, and federal preemption does not negate the need to comply with state laws where applicable. This approach could lead to overlooking state-specific disclosure requirements, licensing obligations, or consumer protection rules. Waiting for explicit guidance from the Alabama Securities Commission or other state regulators before taking any action is a reactive and potentially damaging strategy. While regulatory guidance is valuable, the absence of immediate pronouncements does not absolve a firm of its responsibility to comply with existing laws and to anticipate potential regulatory shifts. This passive approach increases the likelihood of falling out of compliance and facing enforcement actions. Professional reasoning. Professionals should adopt a risk-based approach, prioritizing proactive identification and mitigation of potential compliance issues. This involves continuous monitoring of regulatory developments in the relevant jurisdiction, Alabama, seeking expert legal and regulatory advice, and developing contingency plans. A commitment to understanding the specific legal and regulatory landscape of Alabama, rather than relying on broad assumptions or waiting for directives, is paramount for maintaining ethical conduct and ensuring client interests are protected. Question 7. System analysis indicates that understanding the historical context of Brexit is crucial for financial professionals in Alabama. Which of the following best reflects the core historical drivers of Brexit and their potential regulatory implications for financial services operating within or advising clients in Alabama? Option A. Brexit was primarily driven by a desire for the UK to regain sovereignty and control over its laws and borders, leading to a divergence in regulatory frameworks from the European Union, which necessitates a reassessment of cross-border financial activities and compliance for Alabama-based entities. Option B. Brexit was a consequence of internal political disagreements within the European Union, unrelated to the UK's regulatory autonomy, and thus has no bearing on financial services regulation in Alabama. Option C. Brexit was a purely economic decision aimed at securing new trade deals for the UK, with minimal impact on financial services regulation, and therefore no need for specific risk assessment adjustments in Alabama. Option D. Brexit was solely about immigration control, and its impact on financial services regulation in Alabama is negligible, as it does not directly affect the movement of capital or investment. The correct answer is A. Brexit was primarily driven by a desire for the UK to regain sovereignty and control over its laws and borders, leading to a divergence in regulatory frameworks from the European Union, which necessitates a reassessment of cross-border financial activities and compliance for Alabama-based entities. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an understanding of the historical context of Brexit and its implications for financial services regulation in Alabama, specifically concerning the UK's departure from the European Union. Professionals must navigate the complex interplay between historical events, regulatory frameworks, and their impact on client advice and risk assessment. The challenge lies in accurately recalling and applying the specific historical drivers and their subsequent regulatory consequences within the defined jurisdiction of Alabama. Correct approach analysis. The best professional approach involves accurately identifying the primary historical drivers of Brexit that directly influence the UK's regulatory landscape, and subsequently, how those changes might necessitate adjustments in risk assessment for financial services operating or advising clients in Alabama. This requires a nuanced understanding that Brexit was not a singular event, but a process driven by various political and economic factors, leading to a divergence in regulatory approaches between the UK and the EU. For financial services in Alabama, understanding this divergence is crucial for assessing potential impacts on cross-border transactions, investment strategies, and compliance requirements. The historical context informs the regulatory shifts that Alabama-based professionals must consider. Incorrect approaches analysis. One incorrect approach would be to focus solely on the economic consequences of Brexit without acknowledging the underlying political and social motivations. While economic impacts are significant, they are a result of the historical drivers. Ignoring the historical context leads to an incomplete understanding of the regulatory shifts. Another incorrect approach would be to conflate the regulatory changes in the UK post-Brexit with existing EU regulations. The core of Brexit's impact on regulation is the UK's ability to set its own rules, diverging from the EU. Failing to recognize this divergence means misinterpreting the regulatory environment and potentially providing inaccurate advice. A further incorrect approach would be to assume that Brexit had no material impact on financial services regulation in Alabama. While Alabama is not directly part of the UK or EU, the interconnectedness of global financial markets means that significant regulatory shifts in major economies like the UK can have ripple effects, influencing investment flows, market access, and the regulatory considerations for firms operating internationally or dealing with international clients. Professional reasoning. Professionals should adopt a structured approach to risk assessment that begins with understanding the historical and political context of significant global events like Brexit. This understanding should then be mapped to the specific regulatory frameworks relevant to their jurisdiction, in this case, Alabama. A thorough analysis involves identifying how these historical events have led to regulatory divergence, assessing the potential impact on clients and operations, and ensuring compliance with all applicable Alabama laws and regulations. This requires continuous learning and adaptation to evolving regulatory landscapes. Question 8. The risk matrix shows a potential conflict in Alabama regarding the application of financial regulations that were influenced by EU law principles prior to Brexit. An advisor must determine the current legal standing of these principles in Alabama. Which of the following best describes the appropriate risk assessment approach? Option A. Disregard any historical influence of EU law principles, as Alabama's financial regulations are now entirely independent and unaffected by prior EU legal frameworks. Option B. Focus exclusively on the latest UK post-Brexit financial regulations to understand their potential impact on Alabama's financial advisory landscape. Option C. Assess the current Alabama financial regulatory framework to identify any retained or domesticated EU law principles, such as supremacy, direct effect, or proportionality, and their current enforceability within Alabama. Option D. Assume that all EU law principles are no longer relevant in Alabama for financial regulation purposes due to the UK's departure from the EU. The correct answer is C. Assess the current Alabama financial regulatory framework to identify any retained or domesticated EU law principles, such as supremacy, direct effect, or proportionality, and their current enforceability within Alabama. Explanation. The risk matrix shows a potential conflict arising from the application of EU law principles in Alabama following Brexit. This scenario is professionally challenging because it requires a financial advisor in Alabama to navigate the residual influence of EU law principles, specifically supremacy, direct effect, and proportionality, on financial regulations that may have originated from or been influenced by EU directives, even after the UK's departure from the EU. The advisor must understand how these principles, if still applicable through specific transitional arrangements or domestic legislation in Alabama that incorporated EU law, would interact with current Alabama financial regulations. Careful judgment is required to ensure compliance and provide accurate advice to clients whose investments might be affected. The best approach involves recognizing that, while the UK has left the EU, certain EU law principles might still have indirect relevance in Alabama if they were incorporated into Alabama's regulatory framework prior to Brexit, or if specific bilateral agreements or transitional provisions exist. This approach prioritizes understanding the current Alabama regulatory landscape and how it has evolved, potentially retaining elements of EU law principles through domestic adoption. The justification lies in the principle of territoriality of law. Alabama law governs financial advice within Alabama. If Alabama has legislated to retain or replicate the effects of EU law principles like supremacy, where an Alabama law is deemed superior to conflicting regulations, mirroring EU supremacy over national law. Direct effect, where individuals can rely on certain provisions of Alabama law directly in court, similar to EU direct effect. Or proportionality, requiring regulatory measures to be no more than necessary to achieve their objective. A core EU principle, then these must be considered. This is the most prudent and legally sound method, as it grounds the analysis in the operative legal framework of Alabama. An incorrect approach would be to assume that all EU law principles are automatically nullified in Alabama due to Brexit. This fails to acknowledge that domestic legal systems can adopt or retain principles from other legal orders. The regulatory failure here is a misunderstanding of how international legal principles can be domesticated and continue to have effect within a sovereign jurisdiction. Another incorrect approach is to solely focus on UK post-Brexit regulations without considering their direct applicability or influence on Alabama's specific financial regulatory environment. While UK regulations might be a point of reference, they do not automatically govern financial advice in Alabama. The ethical failure is providing advice based on potentially irrelevant or misapplied legal frameworks, leading to non-compliance and client detriment. A third incorrect approach is to disregard any potential influence of EU law principles altogether, assuming that post-Brexit, Alabama's financial regulations are entirely independent of any prior EU legal influence. This overlooks the possibility of residual effects, or the continued relevance of principles that have become embedded in financial regulation globally, including in the U.S. The professional decision-making process should involve a thorough review of Alabama's current financial services legislation and regulatory guidance, identifying any provisions that may have originated from or been influenced by EU law, and assessing their continued validity and application. This requires consulting legal experts specializing in Alabama financial law and understanding the historical development of relevant regulations. Question 9. Process analysis reveals that understanding the key events leading to the Brexit referendum is crucial for assessing its potential implications within the legal framework of Alabama. Which of the following best describes the primary catalysts that directly precipitated the 2016 Brexit referendum? Option A. The complex and protracted negotiations that followed the referendum vote, determining the terms of the United Kingdom's withdrawal from the European Union. Option B. The perceived bureaucratic overreach of European Union institutions and a desire to restore greater national legislative autonomy. Option C. The Conservative Party's 2015 general election manifesto pledged to hold an out referendum on EU membership, coupled with the subsequent vigorous campaigning by both the Leave and Remain sides, which focused on issues of sovereignty, immigration, and economic impact. Option D. Decades of increasing economic integration within the European Union, leading to a growing sense of loss of national economic control among certain segments of the British public. The correct answer is C. The Conservative Party's 2015 general election manifesto pledged to hold an out referendum on EU membership, coupled with the subsequent vigorous campaigning by both the Leave and Remain sides, which focused on issues of sovereignty, immigration, and economic impact. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an understanding of the complex interplay of political, economic, and social factors that culminated in the Brexit referendum. Misinterpreting these key events can lead to a flawed assessment of the referendum's origins and the subsequent legal and regulatory landscape in Alabama, which is the specified jurisdiction. Careful judgment is required to distinguish between proximate causes and underlying trends, and to connect these to the specific legal framework of Alabama. Correct approach analysis. The best approach involves identifying the core, widely recognized events that directly precipitated the referendum. This includes understanding the Conservative Party's manifesto promise, the subsequent campaign dynamics, and the specific concerns that resonated with a significant portion of the electorate. In the context of Alabama law, this means recognizing how these UK-specific events, while external, laid the groundwork for potential future legal and economic shifts that might necessitate regulatory adjustments or interpretations within Alabama's existing framework, even if indirectly. The justification lies in focusing on the direct causal chain leading to the referendum itself, as this is the most relevant precursor to understanding any subsequent legal implications for Alabama. Incorrect approach is analysis. One incorrect approach would be to focus solely on long-term historical grievances or abstract notions of national sovereignty, without linking them to the immediate triggers of the referendum. While these factors may have contributed to the broader sentiment, they do not represent the key events that directly led to the decision to hold a referendum. This approach fails to provide a precise understanding of the referendum's genesis. Another incorrect approach would be to overemphasize the economic consequences of the UK's membership in the European Union, without acknowledging the political and social dimensions. While economic arguments were central to the debate, the referendum was also fueled by concerns about immigration, national identity, and democratic control. A purely economic focus presents an incomplete picture. A further incorrect approach would be to conflate the referendum campaign with the subsequent withdrawal negotiations. The events leading to the referendum are distinct from the process of leaving the EU. Focusing on the negotiations would be anachronistic and would not accurately address the question of what led to the referendum itself. Professional reasoning. Professionals should approach such questions by first dissecting the prompt to identify the specific jurisdiction and the core topic. They should then recall or research the most direct and widely accepted causal factors for the event in question. The next step is to filter these factors through the lens of the specified jurisdiction, considering how external events might have indirect relevance or necessitate understanding within that jurisdiction's legal or regulatory context. This involves distinguishing between primary drivers and secondary or tangential influences, and prioritizing information that directly addresses the leading to aspect of the question. Question 10. Process analysis reveals that a financial advisor in Alabama is managing a diversified portfolio for a client that includes significant exposure to UK-based companies and assets denominated in British pounds. Following the UK's departure from the European Union Brexit, the advisor needs to assess the potential financial impact on the client's portfolio. The advisor has access to historical market data, company financial reports, and economic forecasts related to Brexit. The advisor's objective is to quantify the potential downside risk to the portfolio's value over the next 12 months, assuming a moderate negative economic shock stemming from ongoing Brexit-related trade adjustments. Calculate the estimated maximum potential loss in portfolio value, expressed as a percentage. If the British pound depreciates by 8% against the US dollar, and the value of UK equities within the portfolio declines by 15% due to reduced trade and investment, assume that 30% of the client's total portfolio value is invested in UK assets, equities, and GBP-denominated bonds. Option A. The estimated maximum potential loss is 15.3%. Option B. The estimated maximum potential loss is 23.0%. Option C. The estimated maximum potential loss is 12.0%. Option D. The estimated maximum potential loss is 8.0%. The correct answer is A. The estimated maximum potential loss is 15.3%. Explanation. The scenario presents a professional challenge for a financial advisor in Alabama dealing with the economic implications of the UK's departure from the European Union Brexit on a client's portfolio. The advisor must navigate the uncertainty and potential volatility introduced by this geopolitical event, which has direct and indirect impacts on international markets, and consequently, on investments held by an Alabama-based client. Careful judgment is required to assess risk, provide accurate advice, and maintain client trust amidst evolving economic conditions. The best professional approach involves a quantitative risk assessment that models the potential impact of Brexit-related economic shifts on the client's specific portfolio holdings. This includes analyzing currency fluctuations, e.g., GBP/USD, changes in trade agreements affecting companies within the portfolio, and broader market sentiment. The advisor should utilize financial modeling tools to project potential downside risks and upside opportunities, quantifying these impacts using metrics like value at risk, VaR, or scenario analysis. For instance, if a significant portion of the client's portfolio is invested in UK equities, the advisor would calculate the potential loss in portfolio value under a severe Brexit-related economic downturn scenario. This approach is correct because it aligns with the fiduciary duty to act in the client's best interest by providing data-driven, objective advice. It directly addresses the regulatory expectation in Alabama for financial advisors to conduct thorough due diligence and risk management, ensuring that investment recommendations are based on a comprehensive understanding of potential market impacts. An incorrect approach would be to rely solely on qualitative assessments of Brexit's impact, such as general news reports or anecdotal evidence, without performing specific calculations. This fails to quantify the risk and may lead to overly generalized or inaccurate advice. Ethically, it falls short of the diligence required to protect client assets. Another incorrect approach is to ignore the potential impact of Brexit altogether, assuming it will not significantly affect the client's investments. This demonstrates a failure to monitor relevant market events and their potential consequences, violating the duty of care and potentially exposing the client to unforeseen losses. A third incorrect approach involves making speculative investment decisions based on personal opinions about Brexit's long-term success or failure, rather than on a calculated assessment of risk and return. This prioritizes the advisor's personal views over the client's financial well-being and deviates from objective, evidence-based financial planning. Professionals should employ a decision-making framework that begins with identifying the specific event Brexit and its potential relevance to the client's portfolio. This is followed by a thorough risk assessment, utilizing quantitative methods to model potential impacts. The results of this analysis should then inform a discussion with the client about potential adjustments to their investment strategy, ensuring transparency and informed consent. Question 11. Which approach would be most prudent for an investment advisor in Alabama when assessing the potential impact of evolving public opinion on Brexit on client portfolios? Option A. Base investment recommendations primarily on personal interpretations of news headlines and social media discussions regarding Brexit. Option B. Focus exclusively on historical market performance data, disregarding public opinion as an unreliable and subjective factor. Option C. Prioritize the investment strategies favored by a small, vocal group of clients who express strong opinions on Brexit. Option D. Conduct a comprehensive risk assessment that integrates quantitative economic data with qualitative analysis of public opinion trends and their potential policy implications. Correct answer is D. Conduct a comprehensive risk assessment that integrates quantitative economic data with qualitative analysis of public opinion trends and their potential policy implications. Explanation. This scenario is professionally challenging because it requires an investment advisor in Alabama to navigate the complex and evolving landscape of public opinion regarding Brexit, a topic with significant economic and political ramifications that directly impact investment decisions. The advisor must balance providing objective, data-driven advice with acknowledging the subjective and often emotionally charged nature of public sentiment. Careful judgment is required to avoid personal bias and to ensure that client recommendations are grounded in sound analysis rather than speculative interpretations of public mood. The best professional approach involves a comprehensive risk assessment that integrates quantitative data on economic indicators and market reactions with qualitative analysis of public opinion trends. This approach is correct because it adheres to the fiduciary duty of acting in the client's best interest by providing a well-rounded perspective. Specifically, within the context of Alabama's financial advisory regulations, which emphasize due diligence and suitability, this method ensures that investment strategies are informed by a thorough understanding of potential impacts, including those stemming from shifts in public sentiment that could influence policy or economic stability. It acknowledges that public opinion, while not a direct regulatory factor, can be a significant driver of market volatility and policy changes, thus necessitating its inclusion in a robust risk assessment. An incorrect approach would be to dismiss public opinion entirely, focusing solely on historical market data. This fails to acknowledge that public sentiment can be a leading indicator of future policy shifts or economic disruptions, and ignoring it could lead to suboptimal investment advice. Ethically, this approach breaches the duty of care by not considering all relevant factors that could affect a client's portfolio. Another incorrect approach would be to overemphasize anecdotal evidence or personal interpretations of public discourse without grounding them in broader data. This risks introducing personal bias and making recommendations based on speculative or unverified information, which is contrary to the principles of objective financial advice mandated by Alabama's regulatory framework. Finally, an approach that solely relies on the opinions of a few vocal individuals or groups without considering the broader spectrum of public sentiment is also professionally unacceptable. This narrow focus can lead to a skewed understanding of public opinion and, consequently, flawed investment strategies. Professionals should employ a decision-making framework that prioritizes objective data analysis, incorporates relevant qualitative factors like public opinion through structured assessment, and consistently applies a suitability standard to all client recommendations, ensuring that advice is tailored to individual risk tolerance and financial goals, all within the bounds of Alabama's regulatory requirements. Question 12. Investigation of the Northern Ireland Protocol's purpose and significance within the framework of Alabama Brexit Law necessitates a comprehensive risk assessment. Considering this, which approach best guides an Alabama-based legal professional in advising a client whose business has supply chain links to both the United Kingdom and the European Union? Option A. Conclude that the Northern Ireland Protocol has no direct legal bearing on Alabama businesses, and therefore no further analysis is required for client advice. Option B. focus exclusively on the historical political motivations behind Brexit, without analyzing the ongoing practical implications of the Northern Ireland Protocol on international trade flows. Option C. Conduct a detailed risk assessment to identify how the Northern Ireland Protocol's provisions on customs, regulatory alignment, and trade might indirectly impact the client's supply chain operations, market access, and compliance obligations. Option D. Assume the Northern Ireland Protocol directly imposes specific customs duties and regulatory requirements on all Alabama businesses trading with the UK or EU, regardless of their specific operational footprint. The correct answer is C. Conduct a detailed risk assessment to identify how the Northern Ireland Protocol's provisions on customs, regulatory alignment, and trade might indirectly impact the client's supply chain operations, market access, and compliance obligations. Explanation. Scenario analysis. The scenario presents a professional challenge involving the interpretation and application of the Northern Ireland Protocol within the context of Alabama Brexit Law. This is professionally challenging because it requires understanding how an international agreement, designed to address specific post-Brexit issues in Northern Ireland, might intersect with or be interpreted under Alabama's legal framework. Even though Alabama is geographically distant and not directly involved in the protocol's negotiation or implementation, the complexity arises from the need to assess potential indirect impacts or the relevance of the protocol's principles to Alabama businesses or legal practitioners engaging with entities affected by it. Careful judgment is required to distinguish between direct legal applicability and indirect relevance or advisory considerations. Correct approach analysis. The best professional approach involves a thorough risk assessment that focuses on identifying potential indirect impacts of the Northern Ireland Protocol on Alabama-based entities. This means analyzing how the protocol's provisions regarding customs, regulatory alignment, and trade might create new operational complexities, compliance requirements, or market access challenges for Alabama businesses that trade with or have supply chains involving Northern Ireland, the Republic of Ireland, or the EU. This approach is correct because it prioritizes a practical, forward-looking assessment of business risks and opportunities stemming from the protocol's existence, even without direct jurisdictional authority. It aligns with professional ethical obligations to advise clients on relevant external factors that could affect their operations and legal standing, drawing upon available information and expert analysis. Incorrect approaches analysis. One incorrect approach would be to dismiss the Northern Ireland Protocol entirely, arguing that Alabama has no direct jurisdiction over its implementation. This fails to acknowledge that international agreements can have ripple effects, creating indirect legal and commercial implications for businesses operating globally. Another incorrect approach would be to assume the protocol directly imposes specific legal obligations on Alabama entities without any mediating legislation or contractual clauses. This overstates the protocol's reach and ignores the principle that international law generally does not directly bind domestic entities unless incorporated into domestic law. Finally, an incorrect approach would be to focus solely on the historical context of Brexit, without considering the ongoing operational and legal realities created by the protocol itself. This would lead to an incomplete and potentially misleading assessment of current risks. Professional reasoning. Professionals should adopt a framework that begins with understanding the core purpose and significance of the Northern Ireland Protocol to avoid a hard border on the island of Ireland and maintain the integrity of the EU's single market while respecting the UK's constitutional arrangements. This understanding should then be applied to a risk-based analysis, considering how these specific objectives and mechanisms of the protocol might indirectly affect the business interests of clients operating from or within Alabama. This involves researching relevant trade agreements, customs procedures, and regulatory divergence points, and then assessing their potential impact on supply chains, market access, and compliance costs for Alabama businesses. The process requires a proactive, investigative mindset, seeking to anticipate challenges and opportunities, rather than waiting for direct legal mandates. Question 13. Assessment of the legal significance of the transition period for a financial services firm operating in Alabama, considering its obligations and agreements that were previously governed by European Union law, requires a careful examination of the regulatory framework in place during that specific timeframe. Which of the following approaches best reflects a professional and compliant assessment of this situation. Option A. Treating the transition period as a mere formality with no substantive legal impact on existing agreements or regulatory obligations. Option B. An assumption that all EU-derived regulations cease to have effect in the UK immediately upon the formal exit date, disregarding the specific provisions of the transition period. Option C. Comprehensive review of all agreements and operational frameworks subject to EU law prior to the end of the transition period, identifying provisions impacted by the cessation of EU membership, and understanding the legal continuity provided by the transition period. Option D. A sole focus on new UK-specific regulations enacted after the transition period, ignoring the continued applicability of certain EU laws during the transition. The correct answer is C. A comprehensive review of all agreements and operational frameworks subject to EU law prior to the end of the transition period, identifying provisions impacted by the cessation of EU membership, and understanding the legal continuity provided by the transition period. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a nuanced understanding of the legal implications of the transition period following the UK's departure from the European Union, specifically as it pertains to financial services operating within Alabama. The challenge lies in accurately assessing the ongoing legal status of certain cross-border agreements and regulatory compliance obligations that were in flux during this period. Professionals must navigate the potential for retrospective legal challenges and ensure ongoing adherence to both UK and potentially relevant US, Alabama, financial regulations. Careful judgment is required to avoid misinterpreting the legal effect of the transition period, which could lead to regulatory breaches or financial misstatements. Correct approach analysis. The best professional practice involves a thorough review of all agreements and operational frameworks that were subject to EU law prior to the end of the transition period. This includes identifying any provisions that were explicitly tied to EU membership or directives that ceased to apply post-transition. The legal significance of the transition period in this context was to provide a defined timeframe during which existing EU law continued to apply in the UK, allowing for a phased adjustment to new arrangements. Therefore, understanding which specific EU regulations were still in force and applicable to the firm's operations in Alabama during that period, and how their cessation impacted ongoing obligations, is paramount. This approach ensures compliance with the legal framework as it evolved and avoids assumptions about the immediate cessation of all EU-derived rights and obligations. Incorrect approaches analysis. One incorrect approach would be to assume that all EU-derived regulations cease to have effect in the UK immediately upon the formal exit date, without considering the specific provisions of the transition period. This fails to acknowledge the legal continuity intended by the transition period, potentially leading to premature cessation of compliance with certain obligations, or the incorrect assumption that certain cross-border arrangements were immediately invalidated. This is a regulatory failure, as it disregards the legally defined interim period. Another incorrect approach would be to solely focus on the new UK-specific regulations enacted after the transition period, ignoring the continued applicability of certain EU laws during the transition. This overlooks the fact that the transition period was designed to prevent a legal vacuum and ensure a gradual shift. Relying only on post-transition regulations would mean failing to account for the legal landscape that governed operations for a significant portion of the period in question, potentially leading to non-compliance with regulations that were still in force. A further incorrect approach would be to treat the transition period as a mere formality with no substantive legal impact on existing agreements or regulatory obligations. This misunderstands the core purpose of the transition period, which was to provide a legally defined bridge between EU membership and the new relationship. Ignoring its legal significance could lead to misinterpretations of contractual clauses, regulatory reporting requirements, and the validity of cross-border financial activities that were still governed by EU law during that time. Professional reasoning. Professionals should adopt a systematic approach to assessing the impact of the transition period. This involves 1. Identifying all relevant EU-derived laws and regulations that impacted the firm's operations in Alabama prior to the end of the transition period. 2. Understanding the specific terms and duration of the transition period as defined in the withdrawal agreement. 3. analyzing how each identified EU law or regulation was affected by the cessation of the transition period, considering any specific carve-outs or grandfathering provisions. 4. Reviewing and updating all relevant internal policies, procedures, and agreements to reflect the new legal and regulatory landscape. 5. Seeking expert legal counsel when in doubt about the interpretation or application of specific regulations. Question 14. Benchmark analysis indicates that a financial advisor in Alabama is reviewing their client's investment portfolio in light of recent global economic shifts. The advisor needs to determine the most effective method for assessing how Alabama's regulatory framework, encompassing both primary and secondary legislation, impacts their advisory duties and client disclosures concerning these shifts. Which approach best ensures compliance and professional diligence? Option A. Systematically review Alabama's primary legislative enactments governing financial services, followed by a detailed examination of all relevant Alabama administrative regulations and agency guidance that implement these statutes, considering how these might be indirectly affected by external economic events. Option B. Focus exclusively on the broad principles outlined in Alabama's primary legislation, deeming secondary regulations as less critical for understanding current advisory obligations in a changing global economic climate. Option C. Assume that Alabama's financial regulatory framework remains entirely unaffected by external geopolitical events like Brexit, and therefore requires no specific consideration beyond general economic risk assessment. Option D. Prioritize researching international economic analyses and news reports related to Brexit's potential market impacts, assuming that general economic principles will sufficiently inform the application of Alabama's financial regulations. The correct answer is A. Systematically review Alabama's primary legislative enactments governing financial services, followed by a detailed examination of all relevant Alabama administrative regulations and agency guidance that implement these statutes, considering how these might be indirectly affected by external economic events. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a financial advisor in Alabama to navigate the complex interplay between primary legislation enacted by the Alabama legislature and secondary legislation, regulations, promulgated by state agencies, all within the context of potential impacts from a significant geopolitical event like Brexit. The advisor must accurately assess how these different layers of law and regulation affect their client's investment portfolio, particularly concerning any specific Alabama-based financial services laws or directives that might have been influenced by or adapted to address such external economic shifts. The risk lies in misinterpreting the hierarchy of legislation or failing to identify relevant secondary legislation that provides detailed implementation or specific requirements not fully elaborated in the primary statutes. Correct approach analysis. The best professional practice involves a systematic approach that prioritizes understanding the foundational primary legislation enacted by the Alabama legislature that governs financial services and investment advice. This will be followed by a thorough review of any relevant Alabama administrative regulations issued by agencies like the Alabama Securities Commission, which provide the detailed rules and procedures for implementing the primary statutes. This layered approach ensures that the advisor is grounded in the overarching legal framework and then addresses the specific, actionable requirements derived from it, considering how these might be indirectly affected by external events like Brexit through their impact on the broader economic and regulatory landscape that Alabama law operates within. This method directly aligns with the principle of statutory interpretation, where primary legislation sets the broad intent and secondary legislation provides the practical application. Incorrect approaches analysis. One incorrect approach would be to solely focus on the potential economic fallout from Brexit without first establishing a clear understanding of the governing Alabama primary and secondary legislation. This overlooks the fundamental legal obligations and regulatory boundaries within which the advisor must operate. Relying solely on general economic analysis or international news without grounding it in specific Alabama law risks noncompliance with state-specific requirements. Another incorrect approach would be to only consider primary legislation and ignore any relevant secondary legislation. This is problematic because secondary legislation often contains the detailed operational rules, licensing requirements, and disclosure obligations that are critical for day-to-day compliance. Primary legislation may provide the broad authority for regulation, but secondary legislation provides the specific mandates that advisors must adhere to. A further incorrect approach would be to assume that Brexit has no direct impact on Alabama financial regulations, and therefore disregard any potential indirect influences or adaptations that might have occurred. While Brexit is an external event, its economic consequences can necessitate adjustments or clarifications in how existing Alabama laws are applied, particularly concerning cross-border investments or the stability of financial markets that Alabama-based clients are exposed to. Ignoring potential indirect impacts could lead to a failure to adequately advise clients on evolving risks. Professional reasoning. Professionals should adopt a hierarchical and comprehensive approach to legal and regulatory analysis. This begins with identifying the primary legislative authority in the relevant jurisdiction, Alabama, in this case, that governs the specific area of practice, financial advisory services. Subsequently, they must meticulously examine all applicable secondary legislation, regulations, issued by the relevant state agencies, as these provide the detailed operational guidance. When considering external events like Brexit, the professional's duty extends to assessing how these events might indirectly influence the interpretation or application of existing primary and secondary legislation, or necessitate specific client disclosures regarding evolving market risks. This involves a continuous process of research, critical analysis, and risk assessment, ensuring that advice is not only legally compliant, but also considers the broader economic and regulatory context. Question 15. Process analysis reveals that following the United Kingdom's departure from the European Union, a financial advisor in Alabama is reviewing past client transactions that were influenced by EU financial directives. The advisor needs to understand the current legal standing and practical implications of rulings made by the European Court of Justice, ECJ, on these transactions and future advisory services within Alabama. What is the most prudent course of action for the advisor to determine the relevant legal framework? Option A. Continue to apply ECJ rulings directly as if they remain binding on all financial services provided within Alabama. Option B. Completely disregard all ECJ jurisprudence, assuming it has no bearing on Alabama's financial regulations post-Brexit. Option C. Consult with legal counsel specializing in international financial law and Alabama's specific regulatory framework to ascertain the current applicability and persuasive weight of relevant ECJ decisions. Option D. Rely on general financial news and non-specialist commentary to interpret the ongoing influence of the ECJ on Alabama's financial sector. The correct answer is C. Consult with legal counsel specializing in international financial law and Alabama's specific regulatory framework to ascertain the current applicability and persuasive weight of relevant ECJ decisions. Explanation. Scenario analysis. This scenario presents a professional challenge for a financial advisor in Alabama following Brexit. The core difficulty lies in navigating the complex and evolving legal landscape that dictates the interpretation and application of financial regulations, particularly concerning cross-border transactions and the residual influence of EU law. The advisor must accurately assess the current legal standing of ECJ rulings in relation to Alabama's financial services sector post-Brexit, a task requiring a nuanced understanding of international law, treaty interpretations, and domestic legislative responses. Misinterpreting the ECJ's role could lead to non-compliance, client detriment, and reputational damage. Correct approach analysis. The most professionally sound approach involves recognizing that, post-Brexit, the direct and binding authority of the European Court of Justice ECJ on financial services regulation within Alabama has ceased. However, it is crucial to acknowledge that ECJ jurisprudence may still hold persuasive value or influence interpretations of existing Alabama laws that were previously aligned with EU directives. Therefore, the best practice is to consult with legal counsel specializing in international financial law and Alabama's specific regulatory framework to determine the current applicability and persuasive weight of relevant ECJ decisions. This ensures compliance with current Alabama statutes and regulations, while also considering any lingering indirect impacts of prior EU legal frameworks. Incorrect approaches analysis. One incorrect approach is to assume that all ECJ rulings remain directly binding on financial institutions operating in Alabama. This fails to acknowledge the fundamental shift in legal sovereignty post-Brexit and could lead to adherence to outdated or inapplicable legal standards, potentially causing regulatory breaches. Another incorrect approach is to completely disregard any ECJ jurisprudence, assuming it has zero relevance. This is flawed because some Alabama financial regulations may have been transposed from EU law, and ECJ interpretations of those original directives could still offer valuable insight into the intent and application of the current Alabama statutes, even if not directly binding. A third incorrect approach is to rely solely on general news reports or non-specialist advice regarding the ECJ's post-Brexit status. This lacks the rigor and specificity required for legal compliance in a regulated industry and risks misinterpreting the nuanced legal realities. Professional reasoning. Professionals in Alabama's financial services sector must adopt a proactive and legally informed approach to regulatory changes. When faced with the impact of significant geopolitical events like Brexit on legal frameworks, the decision-making process should involve 1. Identifying the specific regulatory area affected. 2. Determining the current governing legislation and regulatory bodies within Alabama. 3. Assessing the historical relationship between Alabama's regulations and the relevant pre-Brexit EU legal framework. 4. Seeking expert legal advice to clarify the current status and persuasive authority of any former EU legal pronouncements, such as those from the ECJ. 5. Implementing advice that ensures strict adherence to current Alabama law and regulatory guidance. Question 16. Process analysis reveals that an Alabama-based manufacturing company has a significant supply chain partner located in the United Kingdom. Given the UK's withdrawal from the European Union, what is the most prudent approach for the Alabama company to assess and manage potential risks arising from the withdrawal agreement? Option A. Prioritize exploring new market opportunities in the UK post-Brexit, deferring any detailed analysis of the withdrawal agreement's implications until operational challenges arise. Option B. Seek general advice on international trade best practices without specifically analyzing the provisions of the withdrawal agreement. Option C. Conduct a detailed risk assessment focusing on how the withdrawal agreement specifically alters trade, regulatory, and contractual frameworks impacting the supply chain relationship and develop targeted mitigation strategies. Option D. Assume the withdrawal agreement has no direct operational impact on an Alabama business and continue existing contractual arrangements without modification. The correct answer is C. Conduct a detailed risk assessment focusing on how the withdrawal agreement specifically alters trade, regulatory, and contractual frameworks impacting the supply chain relationship, and develop targeted mitigation strategies. Explanation. Scenario analysis. This scenario is professionally challenging because it requires navigating the complex and evolving legal landscape following the United Kingdom's withdrawal from the European Union (Brexit) as it pertains to Alabama businesses. The withdrawal agreement, while establishing a framework, introduces new compliance considerations for businesses operating across the new UK-EU border. Professionals must assess the specific implications of the agreement on their operations, supply chains, and contractual obligations, ensuring adherence to both UK and potentially EU regulations that may still indirectly affect Alabama-based entities with cross-border interests. The risk lies in misinterpreting the agreement's provisions, leading to non-compliance, financial penalties, or disruption of business activities. Correct approach analysis. The best professional approach involves a comprehensive risk assessment specifically tailored to the implications of the withdrawal agreement on the Alabama business's operations. This entails identifying all touchpoints with the UK and EU, analyzing how the agreement alters existing trade, regulatory, and legal frameworks, and then developing mitigation strategies. This approach is correct because it directly addresses the core requirement of understanding and managing the risks introduced by the withdrawal agreement. It aligns with professional ethical obligations to act with due diligence and competence, ensuring the business remains compliant and minimizes potential disruptions. Regulatory justification stems from the need to understand and adapt to new legal realities post-Brexit, as outlined in the principles of international trade law and the specific provisions of the withdrawal agreement itself. Incorrect approaches analysis. One incorrect approach is to assume that the withdrawal agreement has no direct impact on an Alabama business simply because it is not based in the UK or EU. This fails to acknowledge the interconnectedness of global commerce and the potential for indirect effects on supply chains, customer bases, or contractual partners that may be located in or heavily reliant on the UK or EU. This approach constitutes a significant regulatory and ethical failure by neglecting due diligence and potentially exposing the business to unforeseen compliance issues. Another incorrect approach is to rely solely on general advice regarding international trade without specific reference to the withdrawal agreement. While general advice is useful, it lacks the precision needed to address the unique legal and regulatory shifts brought about by the UK's departure from the EU. The withdrawal agreement contains specific provisions that supersede or modify previous arrangements, and a generic approach risks overlooking these critical details, leading to non-compliance with the agreement's terms. This is an ethical failure in providing competent advice. A further incorrect approach is to focus only on potential new market opportunities in the UK or EU, without a thorough understanding of the regulatory hurdles and compliance requirements introduced by the withdrawal agreement. This overly optimistic outlook, without a corresponding risk assessment, can lead to strategic missteps and operational challenges. It fails to meet the professional standard of providing balanced advice that considers both opportunities and risks, particularly those stemming from specific legal instruments like the withdrawal agreement. Professional reasoning. Professionals should adopt a structured risk assessment framework. This involves 1. Identifying all relevant cross-border activities and dependencies related to the UK and EU. 2. Researching and understanding the specific provisions of the withdrawal agreement and any subsequent UK or EU legislation implementing it. 3. Analyzing the potential impact of these provisions on the business's operations, contracts, and regulatory obligations. 4. Developing and implementing appropriate mitigation strategies and compliance plans. 5. Regularly reviewing and updating assessments as the post-Brexit landscape continues to evolve. This systematic process ensures that decisions are informed, compliant, and strategically sound. Question 17. The efficiency study reveals that a financial services firm operating in Alabama is concerned about the potential impact of Brexit on its operations and client base within the state. The firm's internal risk assessment team has proposed several strategies to address these concerns. Which of the following approaches best aligns with the regulatory framework governing financial services in Alabama and the implications of Brexit? Option A. Rely on general international best practices for risk management and assume that these are sufficient to cover any Brexit-related impacts on the firm's operations within Alabama. Option B. Conclude that Brexit is primarily an international issue and therefore has no direct legal or operational implications for the firm's compliance with Alabama financial services regulations. Option C. Proactively analyze and document how the firm's risk assessment framework addresses the specific implications of Brexit on Alabama's financial services regulatory landscape, implementing and documenting necessary adjustments to risk mitigation strategies in alignment with Alabama statutes. Option D. Make informal, undocumented adjustments to the firm's risk management procedures based on media reports about Brexit, without consulting Alabama-specific regulations or legal counsel. The correct answer is C. Proactively analyze and document how the firm's risk assessment framework addresses the specific implications of Brexit on Alabama's financial services regulatory landscape, implementing and documenting necessary adjustments to risk mitigation strategies in alignment with Alabama statutes. Explanation. The efficiency study reveals a potential conflict between a firm's internal risk assessment procedures and the specific requirements of Alabama law concerning the implications of Brexit on financial services. This scenario is professionally challenging because it requires a nuanced understanding of how a significant geopolitical event, like Brexit, impacts regulatory compliance within a specific U.S. state's legal framework, particularly when that framework may not have explicitly anticipated such an event. The firm must navigate potential ambiguities and ensure its risk management practices are not only internally sound, but also legally defensible under Alabama statutes. Careful judgment is required to balance business objectives with strict adherence to state law. The best approach involves proactively identifying and documenting how the firm's existing risk assessment framework addresses the specific implications of Brexit as they pertain to Alabama's regulatory landscape. This includes analyzing potential impacts on client relationships, operational continuity, data privacy, and any cross-border financial activities that might be affected. The firm should then implement or adjust its risk mitigation strategies based on this analysis, ensuring these adjustments are clearly documented and aligned with Alabama's financial services regulations. This approach is correct because it demonstrates a commitment to understanding and complying with the specific legal requirements of Alabama, even when those requirements are indirectly influenced by international events. It prioritizes a thorough, documented, and legally compliant risk management process, which is essential for maintaining regulatory standing and client trust within the state. An incorrect approach would be to assume that general risk management principles or regulations from other jurisdictions are sufficient to address the implications of Brexit within Alabama. This fails to acknowledge that Alabama law governs financial services within its borders, and any risk assessment must be tailored to that specific legal context. Relying on generic international guidelines or practices from other states without a specific analysis of Alabama's statutes and regulatory guidance would constitute a significant regulatory failure. Another incorrect approach would be to dismiss the implications of Brexit as an international issue with no direct bearing on Alabama-based operations. This demonstrates a lack of foresight and a failure to appreciate how global events can have tangible legal and operational consequences within a state's jurisdiction. Such an oversight could lead to non-compliance with Alabama's financial services laws, potentially exposing the firm to regulatory penalties and reputational damage. Finally, an approach that involves making ad hoc adjustments to risk management without proper documentation or legal review is also professionally unacceptable. This lack of a structured and documented process increases the likelihood of errors and omissions, making it difficult to demonstrate compliance if challenged by regulators. Professionals should employ a decision-making framework that begins with identifying the specific jurisdiction's regulatory requirements. This should be followed by a thorough analysis of how external events, such as Brexit, might intersect with those requirements. The next step involves assessing the potential risks and developing mitigation strategies that are both effective and compliant with the relevant laws. Crucially, all steps should be meticulously documented and subject to internal review, and, where necessary, legal counsel to ensure full adherence to the governing regulatory framework. Question 18. Quality control measures reveal that a financial advisor in Alabama is reviewing a client's international investment portfolio, which includes significant holdings in European equities and UK-based bonds. The advisor needs to assess how the UK's various trade agreements negotiated post-Brexit might influence the performance and risk profile of these specific assets. Which of the following approaches represents the most prudent and compliant method for the advisor to undertake this assessment? Option A. Conduct a detailed analysis of each relevant UK trade agreement, examining its specific provisions related to financial services, tariffs, and regulatory alignment, and then evaluate the direct and indirect impacts on the client's European equity and UK bond holdings, considering factors like currency fluctuations and market access. Option B. Assume that the UK's trade agreements have minimal impact on investments outside of the UK and focus solely on domestic Alabama market conditions for portfolio adjustments. Option C. Rely on general news articles and commentary from financial commentators to form an opinion on the overall economic sentiment surrounding the UK's post-Brexit trade relationships and adjust the portfolio based on this sentiment. Option D. Apply a broad assumption that all UK trade agreements have led to a universally negative economic outcome for European markets, and therefore recommend divesting from all European equities without further specific analysis. The correct answer is A. Conduct a detailed analysis of each relevant UK trade agreement, examining its specific provisions related to financial services, tariffs, and regulatory alignment, and then evaluate the direct and indirect impacts on the client's European equity and UK bond holdings, considering factors like currency fluctuations and market access. Explanation. Scenario analysis. This scenario presents a professional challenge for a financial advisor operating in Alabama, particularly concerning the implications of the UK's post-Brexit trade agreements on investment strategies for clients with international portfolios. The complexity arises from the need to navigate evolving international trade law, understand its direct and indirect impacts on various asset classes and markets, and translate this understanding into actionable, compliant advice. A failure to accurately assess these impacts could lead to suboptimal investment performance for clients, regulatory breaches, and reputational damage. Careful judgment is required to distinguish between speculative interpretations and evidence-based assessments of trade agreement effects. Correct approach analysis. The best professional practice involves a thorough, evidence-based assessment of the UK's trade agreements post-Brexit and their specific impacts on the client's existing portfolio and potential new investments. This approach requires consulting official government publications, reputable financial analysis reports, and legal interpretations of the trade agreements. The advisor must then analyze how these agreements might affect tariffs, regulatory alignment, market access, and currency exchange rates relevant to the client's holdings. This aligns with the fiduciary duty to act in the client's best interest, requiring diligence and a deep understanding of factors influencing investment outcomes. Specifically, under Alabama law and general financial advisory ethics, advisors are obligated to conduct due diligence and provide advice based on sound research and analysis, not speculation. This approach ensures that investment decisions are informed by a realistic understanding of the economic and legal landscape shaped by Brexit. Incorrect approaches analysis. One incorrect approach involves relying solely on general media headlines and anecdotal evidence regarding Brexit's impact. This is professionally unacceptable because it lacks the rigor required for informed financial advice. Media reports can be sensationalized or lack the specific detail needed to assess trade agreement effects on particular investments. This approach fails the due diligence standard and could lead to decisions based on misinformation, violating the duty of care owed to the client. Another incorrect approach is to assume that all UK trade agreements have a uniformly positive or negative impact across all sectors and asset classes. This oversimplification ignores the nuanced nature of trade deals, which often have sector-specific provisions and varying degrees of impact depending on the industry, trading partner, and the specific terms of the agreement. Such a generalized assumption bypasses the critical analysis necessary to identify specific risks and opportunities for the client's portfolio, potentially leading to misallocation of capital and failure to meet investment objectives. A further professionally unacceptable approach is to disregard the UK's trade agreements entirely, assuming they have no material impact on investments outside the UK. This is a failure to recognize the interconnectedness of global economies. Post-Brexit trade agreements can influence global supply chains, commodity prices, currency valuations, and investor sentiment, all of which can indirectly affect investments held by an Alabama-based client, even if those investments are not directly tied to the UK. This approach demonstrates a lack of awareness of broader economic forces and a failure to conduct comprehensive risk assessment. Professional reasoning. Professionals should adopt a systematic approach to assessing the impact of geopolitical events like Brexit on client portfolios. This involves 1. Identifying relevant events and their potential scope of influence. 2. Gathering credible and specific information from authoritative sources. 3. Analyzing the direct and indirect impacts on relevant markets and asset classes. 4. Quantifying, where possible, the potential risks and opportunities. 5. Integrating this analysis into tailored investment recommendations for the client, clearly communicating the rationale and any associated uncertainties. This structured process ensures that advice is grounded in robust analysis and serves the client's best interests within the regulatory framework. Question 19. Governance review demonstrates that following the United Kingdom's withdrawal from the European Union, an individual who previously resided in Alabama under the assumption of EU free movement rights now faces uncertainty regarding their immigration status. What is the most appropriate approach for an immigration legal professional in Alabama to advise this individual? Option A. Conduct a thorough assessment of the individual's current immigration status under both pre- and post-Brexit UK regulations, and then meticulously apply the relevant Alabama and federal U.S. immigration laws to determine eligibility for continued residency or new visa pathways. Option B. Recommend that the individual proceed with their existing documentation and assume that the transition from EU free movement to a post-Brexit status will be seamlessly managed by U.S. immigration authorities without specific application or re-evaluation. Option C. Advise the individual that their previous EU free movement rights, while altered by Brexit, should still provide a basis for continued residency in Alabama, without requiring a re-evaluation of their U.S. immigration status. Option D. Focus solely on advising the individual about the latest UK immigration rules and regulations post-Brexit, assuming these will adequately address their residency needs in Alabama. Correct answer is A. Conduct a thorough assessment of the individual's current immigration status under both pre- and post-Brexit UK regulations, and then meticulously apply the relevant Alabama and federal U.S. immigration laws to determine eligibility for continued residency or new visa pathways. Explanation. Scenario analysis. This scenario is professionally challenging because it requires navigating the complex and evolving landscape of immigration law in Alabama following the United Kingdom's departure from the European Union. Professionals must balance the legal rights and obligations of individuals with the specific regulatory framework established by Alabama and federal U.S. immigration law, which has been significantly impacted by Brexit. Careful judgment is required to ensure compliance and avoid adverse consequences for clients. Correct approach analysis. The best professional practice involves a comprehensive assessment of the client's current immigration status under both pre- and post-Brexit UK regulations, and then meticulously applying the relevant Alabama and federal U.S. immigration laws to determine eligibility for continued residency or new visa pathways. This approach prioritizes accuracy and thoroughness, ensuring all legal requirements are met. Specifically, it necessitates understanding how an individual's previous EU free movement rights have been affected by Brexit, and how those changes interact with U.S. immigration policies for individuals seeking to establish or maintain a presence in Alabama. This detailed, step-by-step legal analysis is crucial for providing sound advice and achieving the desired immigration outcome within the established legal parameters. Incorrect approach is analysis. One incorrect approach involves assuming that pre-Brexit immigration statuses automatically translate to continued eligibility for residency in Alabama without re-evaluation. This fails to acknowledge that Brexit fundamentally altered the legal basis for many individuals' rights, and U.S. immigration law does not automatically recognize UK-specific post-Brexit statuses. This approach risks misinforming clients and leading to violations of U.S. immigration law. Another incorrect approach is to solely rely on general advice regarding UK immigration rules post-Brexit without considering the specific requirements of Alabama and federal U.S. immigration law. While understanding UK regulations is a component, it is insufficient on its own. U.S. immigration law is distinct and has its own set of criteria for entry, stay, and work, which must be independently satisfied. This approach overlooks the critical need for compliance with the jurisdiction where the individual intends to reside or work. A further incorrect approach is to advise clients to proceed with applications based on outdated information or assumptions about the ease of transitioning between UK and US immigration systems. The post-Brexit environment has introduced new complexities and potential barriers. Relying on assumptions rather than current, specific legal guidance for Alabama and federal U.S. immigration law can lead to rejected applications, loss of legal status, and significant personal and professional repercussions. Professional reasoning. Professionals should adopt a systematic approach that begins with a thorough understanding of the client's individual circumstances and their pre-Brexit immigration status. This should be followed by a detailed analysis of how Brexit has impacted their rights under UK law. Crucially, the next step must be to meticulously research and apply the current Alabama and federal U.S. immigration laws and regulations relevant to their situation. This involves consulting official government resources, seeking clarification from immigration authorities when necessary, and staying abreast of any changes in policy or legislation. A commitment to ongoing education and a client-centered, legally compliant strategy are paramount in navigating these complex immigration matters. Question 20. Risk assessment procedures indicate that a client in Alabama holds a $500,000 investment portfolio with $300,000 invested in UK-based equities and bonds. Given the ongoing implications of Brexit on the UK economy and currency, the advisor needs to quantify the potential downside risk to the UK portion of the portfolio over the next 12 months. If a value at risk (VaR) analysis incorporating various sterling depreciation scenarios against the US dollar suggests a potential loss of 8% to 12% on the UK assets due to currency fluctuations and market volatility. What is the range of potential capital loss, in US dollars, that the advisor must consider and communicate to the client regarding the UK holdings? Option A. Potential capital loss ranging from $36,000 to $48,000 on the UK assets. Option B. A potential capital loss ranging from $24,000 to $36,000 on the UK assets. Option C. A potential capital loss ranging from $30,000 to $45,000 on the UK assets. Option D. A potential capital loss ranging from $15,000 to $22,500 on the UK assets. Correct answer is B. A potential capital loss ranging from $24,000 to $36,000 on the UK assets. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a financial advisor in Alabama to navigate the complex and evolving legal landscape following Brexit, specifically concerning the valuation of a portfolio heavily invested in UK assets for a client seeking to diversify. The advisor must balance the client's stated objective with the potential for significant, unpredictable currency fluctuations and the legal implications of cross-border investment advice under Alabama and potentially UK regulations, which may not be fully harmonized post-Brexit. The core challenge lies in quantifying and communicating the risk associated with a substantial portion of the client's wealth being tied to a jurisdiction undergoing significant economic and regulatory adjustments. Correct approach analysis. The best professional practice involves a comprehensive risk assessment that quantifies the potential impact of Brexit-related volatility on the client's portfolio value. This includes calculating the potential downside risk of the UK-denominated assets using a value-at-risk (VaR) model, considering various plausible sterling exchange rate scenarios against the US dollar. For instance, if the current portfolio value is $500,000 with $300,000 in UK assets, and a VaR calculation indicates a potential 10% loss in the value of UK assets due to adverse currency movements over the next year, the advisor would calculate this potential loss. $0. 10 times $300,000 equals $30,000. This quantitative assessment, coupled with a qualitative analysis of the regulatory and economic uncertainties, allows for informed client discussions and the development of a diversified strategy that mitigates identified risks. This approach aligns with Alabama's fiduciary duty requirements for financial advisors to act in the client's best interest, which necessitates a thorough understanding and disclosure of all material risks, including those stemming from geopolitical events like Brexit. Incorrect approaches analysis. One incorrect approach would be to solely focus on the historical performance of the UK assets without adequately quantifying the forward-looking risks introduced by Brexit. This fails to acknowledge the fundamental shift in the economic and regulatory environment, potentially leading to underestimating the downside risk. For example, if the advisor only considers the past 5-year average return of UK equities and ignores the potential for a 15% depreciation of the pound sterling against the dollar, they would be providing incomplete and misleading advice. This violates the duty to provide advice based on current and foreseeable market conditions. Another incorrect approach would be to recommend immediate liquidation of all UK assets without a detailed analysis of the client's risk tolerance and the potential tax implications of such a sale. While diversification is a valid goal, a blanket recommendation without considering the client's specific circumstances and the costs associated with rapid divestment is not in the client's best interest. This could lead to unnecessary transaction costs and capital gains taxes, which would negatively impact the client's net portfolio value. A third incorrect approach would be to rely on generalized advice from international financial news sources without performing specific calculations relevant to the client's portfolio and the Alabama regulatory environment. While general awareness is important, specific quantitative analysis tailored to the client's holdings and risk profile is essential for fulfilling fiduciary duties. This approach lacks the rigor required to demonstrate due diligence and a personalized assessment of risk. Professional reasoning. Professionals should adopt a structured, data-driven approach. This begins with a thorough understanding of the client's objectives and risk tolerance. Subsequently, a comprehensive assessment of all relevant risks, including those arising from geopolitical events and their quantifiable impact on the client's specific holdings, must be conducted. This involves utilizing appropriate financial modeling tools and considering various economic scenarios. The findings should then be communicated clearly and transparently to the client, enabling them to make informed decisions. This process ensures compliance with fiduciary duties and promotes sound financial planning.